Judiciary Committee will come to order. We are having a busy agenda today and this week, so need to get started with our business of the day right away. We're going to first open the hearing on Senate Bill 244, authorizing the Attorney General to prosecute any crime that is part of an alleged course of criminal conduct that occurred in 2 or more counties. And if we could have a bill brief from the reviser.
All right, thank you, Madam Chairwoman, and good morning, committee. Senate Bill 244, as you mentioned, does authorize the Attorney General to prosecute any crime that is part of an alleged course of criminal conduct that occurred in 2 or more counties. The amendment is in KSA 75-702, which is our statute concerning the Attorney General's duties and responsibilities. The current law, you can see, provides that the Attorney General appears for the state and deals with civil or criminal matters in our appellate courts and in our federal courts. The Attorney General also appears when required by either the governor or the legislative branch in other courts. And further, in certain circumstances, you've granted the Attorney General prosecuting powers that are concurrent with or equal to the powers that county or district attorneys have in our court system. The provision here that's added is new subsection C2, which begins in line 24. And it simply provides, as I mentioned in the opening, that the Attorney General will have that concurrent authority with any county or district attorney to prosecute any crime or an attempt, conspiracy, or criminal solicitation of any crime that is part of an alleged course of criminal conduct that occurred in 2 or more counties. So again, concurrent with the same powers that the county or district attorney already has, but would be granted to the Attorney General's office. Be happy to answer questions.
Thank you. Committee, any questions? Seeing none, then we will go ahead and invite our first proponent in-person conferee, Chris Kobach, Attorney General for the state of Kansas. No introduction needed, but please introduce yourself and welcome to committee.
Thank you, Madam Chairman and members of the committee. I stand before you as your Attorney General. The reason for this bill might not be evident on the surface. The bill is just about a primary prosecution authority, but the genesis of this bill is in a type of crime wave that's been sweeping the country really just in the last 3 years. It's called organized retail crime. Unlike traditional shoplifting events where the criminal, smashes and grabs, steals whatever 1 or 2 things for personal consumption or to, maybe to sell on the internet or something like that. This is a large scale targeted operation that uses multiple people in multiple cities. You can read the Home Depot testimony. They have been hit particularly hard by this. These are methodical, coordinated attacks on retailers. And it comes in the form of what's now called push-outs. You may have noticed when you shop at Home Depot or Menards or Lowe's, wherever you get your tools these days, that there is no longer someone trying to stop anyone at the door. In fact, there may not even be store personnel anywhere near the door. They no longer try to stop the thieves because they've all adopted a nationwide corporate policy of not having any violent confrontations in the store. And so as a result, they'll get the thieves on camera, but they won't, stop them from carrying them out to the vehicle and then taking off with them. And they're called push-outs because typically now these organized gangs will pick the most expensive items in the store, load the cart with as much expensive merchandise as they can, then literally push the cart out the door, unload it into the van, then drive to the next major retail box store and do the same thing, and then go to the next county and do the same thing, accumulating over $1 million in some cases of merchandise in a single day. It's become a huge problem. Let me just give you some stats on this. Prior to 2019, there was approximately per year $69 billion worth of products stolen from retailers in this fashion. Now it is $509 billion a year. So 69 to 509, almost a tenfold increase. Here's another strange thing that I was really surprised to learn. Kansas is one of the top 10 states that are victims of organized retail crime. That's not per capita. That's in total dollars spent. Kansas and Missouri are both in the top 10, which is really curious. Texas is not in the top 10. New York is not in the top 10, but Kansas and Missouri both are. For whatever reason, perhaps it's our location in the country, who knows? But we are particularly heavily hit by this type of crime. So our intention is to do a number of things to try to stop this. One is we're setting up an organized retail crime task force across the state where we work with retailers, including Home Depot and their counterparts, to try to do sting operations, do things where we can actually coordinate with them to try to catch the individuals. And we're less interested in the individual thieves than we are in the larger organizations that are behind them. But this bill is a critical component of it because it gives us primary prosecution authority, where currently we have none. If you have a crime involving multiple counties. Now, a county the size of Johnson County with its DA's office could probably handle a prosecution involving Johnson, Miami, and Douglas counties altogether. But if something happened in a slightly smaller county, maybe up in Leavenworth, maybe in Manhattan and Salina, it's highly unlikely that the county attorney there is going to have the resources to go after something that involves multiple counties. So this seeks to give us a primary prosecution authority and allow us to move in those cases where the county attorney of a single county probably isn't going to have the resources or the ability or the inclination to take on such a big case. That's a quick summary of what it does, and we're doing everything we can to try to stop this new type of organized retail crime, but we would appreciate your help in making this small step to make it better.
Thank you. Committee, any questions? Senator Gossage.
Thank you, Mr. Attorney General, for being here today. I guess the question I have is, these stores have made a decision not to stop anybody. And they're not doing this in other states, or they are doing this in other states?
These decisions are nationwide decisions of store policy, and I sense frustration that you have, that I do too. You know, what's changed in our culture that we don't even try to stop these people from committing the theft in the first place. That may be a bigger cultural question than what we can solve here, but we can certainly take steps to, I hope, dramatically cut back these incidents of crime in Kansas. Maybe if the crime rates go down, I'm just speculating, maybe then the retailers will start to realize that with a decreased amount of crime, they can try to stop a smaller number. But yeah, I think there is something more culturally afoot here, but it has contributed, absolutely, it has contributed to the problem.
So are they currently just turning this into their insurance, or do they even know?
I assume they're dealing with it in insurance, yeah.
Which would raise insurance rates for everyone.
Exactly.
Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none, then thank you very much for your testimony today. Appreciate it. Thank you. And next we will hear from Eric Stafford, Vice President, Government Affairs, Kansas Chamber of Commerce. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and good morning, committee members. Eric Stafford with the Kansas Chamber, also here on behalf of the Kansas Retail Council, which is an organization under our umbrella. We're the state affiliate for the National Retail Federation, here to express our support for Senate Bill 44. Over the last few years here at the state level in Kansas, the Commerce committees have discussed a bill known as the Inform Act. It did not pass at the state level, but in December in the omnibus bill in Congress, that bill did pass nationally, which was ultimately the goal, but it took a long time to get there. So that bill was dedicated to creating an ability to track who third-party sellers are on websites such as Amazon or Walmart, which allows third-party sellers to try to get to the source of this organized retail crime that the Attorney General discussed. And so this is a growing issue. I think to Senator Gossage's question, there are multiple factors that are impacting retail theft, whether it's lack of prosecution, but also employee safety is a concern for businesses. I think it was in November of last year that the Target CEO stated that their company is expected to lose about $400 million from theft nationwide. Just over the weekend, I saw an article that Walmart is closing 2 stores in the city of Portland because of increased theft and crime at their locations there. And so there's been very little accountability in some parts. And so, and I think too, we're not just talking retail theft here. I think the purpose of this law being brought forward by the Attorney General is the more organized retail crime, where they're going county by county to multiple locations, and the Attorney General's office is kind of hamstrung on their ability to prosecute those type of actions. So this is a growing issue. I think the Inform Act that has passed Congress will help. I think stronger prosecution authority at the state level is also a needed tool, but it is a large concern for the retail community. So we do appreciate this bill being brought forward, and I'm happy to answer any questions at the appropriate time.
Thank you. And just want to clarify, I think at the beginning of your testimony, you said you were testifying on Senate Bill 44, and you mean Senate Bill 244.
I'm sorry, 244, yes.
That's okay. I may have
apologize.
misheard, but just want to clear up the record for sure.
Yeah.
Any questions for Mr. Stafford? Yes, Senator Haley.
Thank you, Madam Chair, and I'm sorry I missed the overview by the reviser. This is just wildly encouraging to see this come forward, you and the Attorney General on this. This is really good. Can you help clarify? So what about the in-house or the systemic thefts that are taking place by employees, oftentimes that are a part or might be a part of the syndicate? This would give jurisdiction for that prosecution as well, or is that a matter of better policing by the employer? As you know, or as we know, there are often sometimes internal a part of that. So would that be in conjunction with, I mean, your testimony talked about Home Depot, only use them for an example. What if Home Depot's employees are systemically contributing to this? Would that make them a party too for the hire?
Yeah, Senator and Madam Chair, Eric Stafford for the Kansas Chamber. I don't believe that this law differentiates between who is committing the crime. I think it's just strengthening, if it's happening in multiple jurisdictions or multiple counties, that it gives the Attorney General the authority to prosecute those types of cases. I don't think it's differentiating on who is responsible for the theft. Is that correct? Okay.
Well, then, thank you, Madam Chair and Ms. Stafford. There have been some allegations about TSA, for example, that was systemically taking items that were coming through, but using them to resell, and not to besmirch TSA, but to parallel that with a retail industry. Would the failure to hire or to police one's own employees who are contributing to what is a criminal syndicate bring the entity that was so irresponsible into play? If Home Depot, and I'm only using them because they were part of the testimony, one of the testimony, if Home Depot allowed these thefts by their hire to occur in a multi-county basis, does that make them somehow culpable in contributing to this larger syndicate?
I mean, if they're complicit in going along with it, but I would assume that Home Depot is not supportive of employees stealing from their company and would want to prosecute their employees. I mean, I think it's not Home Depot's fault that their employees choose to break the law and steal against their employer. I don't know why that would fall back on the employer. I think it should fall. I mean, I know not to steal from my employer, and I don't believe that if I chose to do so, that should be the fault of the Kansas Chamber. I think that should be the fault of me at the end of the day. So I don't think that this should come back on the employer. I think it should fall on the individual who's committing the crime.
Okay. All right. Thank you, Eric. Thank you, Mr. Stafford. Thank you, Madam Chair.
Thank you. Yes, Senator Gossage. And we're going to have to move on from this bill in a few minutes, but go ahead.
Thank you. Just for clarification, I happened to walk in late when the Attorney General was speaking, but I believe that, am I reading here? It says the multi-jurisdictional criminal. So not somebody who left a tag on a blouse, and they're walking out of the store. And that should set up an alarm or whatever. We're talking about this is a big deal with people taking all of this, and it's because it's multi-jurisdictional, which is why the Attorney General needs to step in and get involved.
Yeah.
Am I understanding that right?
Yes, Senator and Madam Chair. Again, Eric Stafford with the Kansas Chamber. I think that going to the Inform Act, which was a separate piece of legislation, the intent was to go after folks that were stealing, multiple pallets of leaf blowers or whatever, and then they're selling the products as new as a third-party seller, whether it's on Amazon or Walmart or eBay. And so the purpose of the Inform Act is for somebody who sells over a certain amount of certain dollar amount of goods on a third-party site, that they have to register with the owner of that site, Amazon, eBay, to try to track geographically who are these companies and where is the merchandise coming from. So if they are selling, 24 gas-powered leaf blowers, and we also ironically had the same amount stolen from our location close to where they're located, that was the purpose of the Inform Act. I think what this goes to and the point that the Attorney General is bringing attention to this is that more organized structure, not stealing one or two items here or there. There is truly an organized retail theft effort out there, and this bill attempts to address that.
Thank you, committee. Other questions? Senator Olson.
Thank you, Madam Chair. The way I see this bill, with us having these rural counties, I really see it'll help our prosecutions happen, because what you have is you got counties that just can't afford to prosecute some of these. And in those small areas, there's a Walmart or whatever that are getting ripped off. Most of them stores have a loss prevention, Home Depot, etc., but they don't want their person running the cash register or whoever chasing that criminal outside. Increases liability for them, could get someone hurt. But I see this as a really good bill, given another option to prosecute these criminals that are stealing from these retailers, and it's happening in a big way. I hear it from my friends at Home Depot and other big stores. So I think this is a great tool.
Thank you, committee. Other questions? Seeing none, then thank you very much for your testimony today, and appreciate the opportunity to hear this important piece of legislation. And committee, please note that you do have proponent written only testimony in front of you from Celinda Gonzalez, State and Local Government Relations Manager for Home Depot. Are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will close the hearing on Senate Bill 244 and open the hearing on Senate Bill 258, enacting the Act Against Abusive Access Litigation to create a civil action for determining whether litigation that alleges any access violation under the Americans with Disabilities Act or similar law constitutes abusive litigation, and authorizes penalties for such abusive litigation. And with that, then, a bill brief from the reviser.
Thank you again, Madam Chairwoman. Again, Jason Thompson, Office of Reviser of Statutes. And I won't repeat the short title. This is one of those short titles that's not very short. Senate Bill 258 does authorize a new kind of action, and so we'll get into that a little bit. What it's doing is authorizing a resident of Kansas or the Attorney General on behalf of a class of residents who is subject to litigation that alleges an access violation to file a civil action in our state courts against the party that initiated that litigation. And what they're seeking is a determination as to whether or not that litigation alleging the access violation is abusive. So that's the big picture here. I'll highlight the terms that are defined at the end of the bill, because that gives you more of an idea of what the bill is about. You'll see those are in subsection D, page 2, beginning in line 13, and then through the end of the bill. So access violation is an allegation that a public accommodation does not provide sufficient access under either the federal Americans with Disabilities Act, the ADA, or our Kansas statutes that are similar to the ADA. Public accommodation, of course, has a meaning provided by federal law. And in this case, we also make specifically clear that it includes a website operated by a resident. As you'll hear from the testimony, a lot of these cases involve accessibility of websites. And that's one of the things that this bill would attempt to address. And then finally, resident of this state not only means a person residing here, but it also means an entity that is filed with the Secretary of State's office under our corporate code or under Chapter 17. So it would include businesses as well. And you'll hear from some business folks as to why they're involved in these and might want to bring this kind of action about abusive litigation. I won't go through too many of the details. I know you've got conferees behind me that'll do a lot of that. I will just highlight for you that this civil action would be brought in state court, while the action about access might be brought in a state or federal court, right? So this is a separate action from the one alleging the violation. This is just an action that would be filed in our state court to determine whether or not the other action is abusive. There are a number of factors set forth in the bill as to whether it is abusive litigation or not. Those are listed at the bottom of page 1, beginning in about line 26, and then on to page 2. Looking at past conduct and then conduct in that other action, for example, to determine whether it's an abusive litigation that they're engaged in. And if it's found that it is abusive, our state court would then be able to award reasonable attorney fees and costs in both the current action to determine whether it's abusive and also the other action that was brought about the access violation itself. So that's the big picture. I'll try not to take any more of the time from the conferees. I know this had a comparable hearing in the House last week, and you got a lot of folks here that want to speak on it. So I'll answer questions and get out of the way.
Thank you for the bill brief. Committee questions for the reviser. Seeing none, then we do have a limited amount of time in committee, so I'm going to ask each conferee to limit their testimony to 3 minutes, and I'll have a timer to help us keep on schedule to make sure that we have an opportunity for everyone to have a chance to testify, and we will hold questions until all the proponents, have spoken, and then we will ask all the opponents to speak and ask that side questions. So with that, then invite Mr. Eric Stafford, Vice President, Government Affairs for the Kansas Chamber of Commerce, with Josh Nye, partner, Kriegshauser Nye Law Group, to the podium. Please introduce yourself and welcome still in committee.
Thank you again, Madam Chair, and good morning. Eric Stafford with the Kansas Chamber. I'm going to speak very, very fast as we are here in support of Senate Bill 58. That is a bill that's addressing abusive litigation under the guise of admissibility under the Americans with Disabilities Act. We come to you today trying to address a problem that we thought the legislature fixed in 2017 with the passage of Senate Bill 50, when the legislature created a definition for the unauthorized practice of law when plaintiffs' attorneys were targeting financial institutions for having websites that were not ADA compliant. However, there are no federal guidelines dealing with ADA website compliance and what those standards are. So attached to our testimony is a report from the U.S. Chamber Institute for Legal Reform highlighting the abuse of this legal system. And they discuss in that report the fact that there are serial plaintiffs as well as serial attorneys. You're going to hear from a small business owner here in Kansas shortly who's currently being sued over this. But in those cases, there were some restaurants who were sued, and there were the same plaintiffs listed over 1,000 pieces of or 1,000 lawsuits. Additionally, if businesses choose to settle, which is ultimately the goal isn't fixing websites. The goal is to just get money. So if those businesses settle, then they essentially put a mark on their back for copycat lawsuits and copycat settlements that other businesses in other states will see and potentially pursue those businesses as targets. So 85% of ADA lawsuits are filed in California and New York. Our goal is not to deter ADA accessibility issues or legitimate claims, but our goal, however, is to deter these serial attorneys and serial lawsuits from preying on Kansas businesses through the cause of action created in this bill. So we have heard from the DRC. We've been in conversations with DRC here in Kansas. And I think they're testifying in opposition to this bill. Included in this folder, we have an amendment that we drafted and went through with them Friday. I didn't get it included with my testimony because it wasn't done in time. We had a call that went till after 5 o'clock on Friday, trying to address the issues that were brought up in the hearing on the House side. So in this amendment, I'm happy to present this to the revisor so the committee can have copies. They had asked for a purpose statement as to why this legislation is necessary. So we include a purpose statement. We also include some new language that Josh will get into shortly on how to potentially tighten up and giving DRC recognition to authorize legitimate claims in the state of Kansas. And if they do so, that creates a rebuttable presumption that that claim is legitimate. So if they're starting to get these phone calls from these New York attorneys trying to file suit against Kansas businesses, they could say, yeah, we don't believe this is a legitimate claim, and they're not going to get that rebuttable presumption. So we're trying to take comments and concerns heard from the House hearing, address them in an amendment. We're not to a point where we are in agreement yet, but I cannot urge this committee enough to know that time is short. We're towards the end of session, but we do have Kansas businesses being targeted unfairly. Again, not with any goal of finding resolution to website compliance, but just searching for settlements, quick settlements from businesses to make money in states outside of the state of Kansas. So happy to answer any question and save time for other conferees on this bill, and appreciate the opportunity to be here today, Madam Chair.
Thank you. Is Mr. Nye a separate conferee? Okay, so then we'll hear from Josh Nye, partner Kriegshauser Nye Law Group.
Thank you, Madam Chair and committee. I will also make this brief, but I am here to talk about the mechanics of how this might work in state court. Since we brought this issue to the Kansas Chamber's attention, this is our best shot at solving what seems to be a problem that is difficult to get our hands around. As Eric mentioned, 2017, we thought we had something solved in that bill. Lo and behold, instead of these New York firms coming to Kansas financial institutions with demand letters, they just skip that process and file in the Southern District of New York. In Southern District of New York, there's letter practice. And so even for us representing our plaintiff or the defendant that you'll hear from today, a small business owner, a retail owner in Lindsborg, Kansas, selling Swedish products and Swedish goods. He's been sued in Southern District of New York, and New York has letter practice. And so we can't even file a motion to dismiss or remove jurisdiction until we've at least engaged in 2 different rounds of letters with counsel and then court. And then we can file our motion. And so the plaintiffs' counsels are very smart. They know how to do a legal shakedown, and that's really what this is. File in Southern District in New York, and when they the way that our client found out that he was being sued was not that he was served with process, but about 3 or 4 months prior to that, he starts receiving promotional material in the mail from New York Defense Counsel saying, "Hey, we'll represent you in this case that he doesn't even know about." And so, since time is short, I really want to talk about why these are different than the types of claims we're not trying to deter. Meritorious claims brought by persons looking to seek accommodation or to bring businesses into compliance. That is not the interest of these lawyers, because the ADA has a fee shifting provision. That fee shifting provision allows for attorney's fees in these types of cases, but it does not allow for compensatory damages, any monetary damages. So the point of these lawsuits is solely to get attorney's fees. If our client says the next day, "Hey, I've hired an expert IT firm to come in, make sure my website is compliant," the response we got from these New York lawyers was, "Well, we don't really know what is compliant. Really, our only settlement offer is going to be that you have 1 year to become compliant, but we're not going to tell you what that is." And really, there's not even agreement within the industry, specifically with regards to websites, what compliance even looks like, because the DOJ hasn't even provided guidance on this. And so at the end of the day, these lawsuits are designed as a legal shakedown to tailor the settlement amount to the exact amount that it probably would take to defend this in court through a motion to dismiss stage, which is about $10,000 to $15,000. Ultimately, we're looking for a solution. This may not be it, but it is a real problem. We've seen the DAs in California try to approach this from a antitrust point of view.
We're over our 3 minutes, but
sounds good. I'm happy to stand for questions on how this would actually work. The thing that I'll conclude with is it's a problem. We're not wedded to any particular solution, but we need a solution, and we need it now. Thank you.
Thank you. Appreciate that. Next, we will hear from Corey Peterson, owner Hemshold Inc. from Lindsborg, Kansas. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. Thank you for taking time to hear about the situation and give consideration to what we can do to protect small businesses in Kansas. My name is Corey Peterson. I'm the president of Hemsloyd. Don't feel bad about the pronunciation because I'm constantly explaining how to pronounce it and spell it. So don't feel bad at all about that. My own employees have a little trouble on occasion. So, but anyway, we do sell Scandinavian gifts, not only in Kansas, but across the country in North America. We have a brick and mortar business in Lindsborg, Kansas. And then we sell over with e-commerce, and we still print a catalog. We send 40-page catalog around the country. So that is our business. It was founded in 1984. My wife and I purchased it in 2011. And we have five full-time employees, about 14 part-time employees, and a few seasonal people in the Christmas season as well. I'm here to support Senate Bill 258, as well as to give you a little glimpse into a situation I'm facing. I have a lot that I'd like to say, but my counsel has asked that I limit my comments due to the fact that I do have an active case ongoing against me in the state of New York. So I'm forced to be brief, so I'll try to get under the 3 minutes. But I'm here to tell not only my story, but the story of other small businesses in Kansas. There are thousands of these lawsuits being filed nationwide. I know of several here in the state of Kansas just in the last few months. So I know that it's happening to other small businesses in Kansas. So I'm here not only to represent myself, but hopefully the other small businesses. But the key thing is, I'm not here to debate the importance of accessibility. I know the importance of accessibility. We want to reach as many customers as I can reach. And at first, I was a little upset about what was happening, but then I realized it wasn't about what it's about. So, but anyway, each day, small business owners know that we're going to face a lot of challenges every day we get up. Some routine, some unique, some mundane, and some not so much. And we have personnel issues we deal with, supply chain disappointments, marketing, sales. Is equipment going to break down? Cash flow, do I have enough cash to keep the doors open? And customer relations, and then also community affairs. A lot of small business get involved with. These are examples of what we expect to face. What's happening to me today would not be on that list. I had no idea that this would come up. Since learning of the lawsuit and going through the process of figuring out what is happening out there, I wondered, how could this be happening? What world does this even seem like this could be a right thing? But anyway, I have lost countless nights of sleep, days of work time, and much faith in the process, to be honest. I've never been sued before. I don't know if you have, but it's a terrible feeling. Horrible. And I know I'm not alone in this again. And I know there's a lot of small businesses that are out there trying to do the right things for the right reasons, and then they have to deal with this. As a small business owner, it's not only it is devastating on many fronts. It's frightening to know how alone we are. Am I about there? Okay, I'll close. But there's very few means or very little means for us to even defend ourselves. Small businesses don't have the means to go to states on the East Coast in which to represent ourselves. It's just very difficult to do. The people doing these suits know this, and that's why they're targeting us. So anyway, thank you again for your time. I feel like small business owners, and I use this cliche before, metaphor, we're merely sitting ducks on a very small pond, and there's no limit to the number of ducks that can be shot. And that's the way I feel as a small business owner. But anyway, thank you again for your time and listening. And I wish everyone the best of trying to find some solution to protect small businesses in Kansas. Thanks.
Thank you. Next, we will hear from Daniel Murray, Kansas State Director, National Federation of Independent Business. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Dan Murray, Kansas State Director for the National Federation of Independent Business. NFIB is the voice of small business. We represent nearly 4,000 small business owners, including Mr. Peterson, many of whom are retailers, and most of whom are below 10 employees. This bill fights back against abusive plaintiffs' attorneys who are baselessly using the ADA to attack underfunded and unsuspecting small business owners. Mr. Peterson mentioned they don't have the in-house attorneys. They don't have the in-house capabilities to push back against these lawsuits. And so we need solutions like this bill to address these concerns. Predatory trial attorneys have taken up these efforts. In my testimony, I mentioned some of the statistics we've seen in this growing practice. We need to, again, address this issue here in Kansas in some form or fashion to help folks like Mr. Peterson and others. And I know the time is short, but I did want to just kind of finish with the ADA was advocated by Senator Bob Dole, whom we know is a native treasurer and son, and is being shamelessly used by predatory trial attorneys to shake down small business owners in Kansas who can't afford the time to address these needless lawsuits. Again, it's not about accessibility. It's about trying to earn money off the backs of the backbone of the economy, the small business sector. So with that, Madam Chair, I'll stand for questions.
Thank you. Committee, we will now take any questions for any of our proponent conferees. Yes, Senator Wilborn.
Thank you, Madam Chair. I'd like to ask Mr. Nye a question, if he would come forward. And again,
please approach the podium, Mr. Nye. Thank you.
Thank you. The question is there any model legislation or successful legislation in some other state that could be copied or looked at?
That was actually my my testimony. I forgot to mention it. We actually looked for specific legislation that would allow for some sort of redress in state court. This is modeled on similar legislation out of Washington State, but not with respect to these types of lawsuits, but in a domestic action. And so there's at least two different bills, I think, that we've drawn through, or laws we've drawn from, but that had to do with, you know, when domestic partners or spouses are filing abusive or putative aimed PFAs or other types of process in the domestic court, that there would be this type of fee shifting. And so we're looking for it. I don't think any state has figured it out yet. The antitrust angle of the San Francisco DA got dismissed. There has been in the 11th Circuit a sanction of attorneys that bringing these lawsuits where they had a 50-50 fee splitting regime with their plaintiff clients to give them half of their attorney's fees. And so people are trying, states are trying, and it has bubbled up to courts. It's just very expensive to try to litigate these rights in court, especially in federal court in the Southern District of New York. This would at least give a state review at the beginning of the case. And then again, in the Balloon Amendment, there'd be a re-review to make sure meritorious lawsuits weren't being deterred. But if this is solely for the purpose of shaking people down, that could be a finding in the state action. We're open to suggestions, but we drew from those other types of abusive litigation acts that apply in other contexts. But as soon as Kansas stops being a mark for Kansas businesses, they're going to move on to another state, and I think that state will join the conversation.
Senator Corson.
Thank you, Madam Chair. I have several kind of technical questions, but in the interest of time, I want to ask kind of one overarching question. And I understand it's not your intent to limit these suits or to limit the meritorious ones, certainly. But I really worry that that's going to have the effect, that will be the effect of this, whether or not that's your intent. Because one of the things that was left out, I think inadvertently from the bill brief, is that in addition to damages, the court can award punitive damages or sanctions not to exceed 3 times the amount of attorney's fees awarded by the court. So I worry that if we implemented this law, it would just have a massive chilling effect in attorneys being willing to take on even meritorious cases because they just simply don't want to expose themselves to that kind of legal risk. So that's my overarching concern, and we just appreciate your feedback on that. Thank you, Madam Chair.
Well, this particular area of law in the ADA has a complicated public and private cause of action. The DOJ can enforce it, and the DOJ can actually retrieve monetary damages in those cases. If a private actor brings a suit, they're bringing injunctive relief only. And so the whole purpose, theoretically, is for that suit to bring about compliance. And so there are all kinds of meritorious one-off cases that are brought, especially by Kansas attorneys in federal court that would seek to bring compliance. And then there's no need for an injunction in court and to litigate it all the way to the end of the case if there can be a settlement reached. The problem with these is that while we have the hypothetical of deterring the good egg, the good case, we have a real world, not hypothetical at all, continued abuse of this particular approach. And so we have one attorney the attorney in our case has brought over 801 cases. 250 of them are pending across the nation. Not one of them has been tried to the merits. So at the end of the day, we have a reality of an abusive process and a hypothetical of the potential for a meritorious claim. What this balloon does is it provides an initial review of whether the litigation is abusive, taking into account, letting us as defense attorneys right off the bat say, we've offered to bring it into compliance. In fact, we have brought it into compliance. Why do we still need a case seeking an injunction in the Southern District of New York? Well, the reason is they want their attorney's fees and they want to shake us down. What we've done in the balloon is the court in Kansas would re-review that initial determination so that if a case was successful on the merits, ultimately, and it was actually tried to completion in federal court in New York, that would be a rebuttable presumption that it was not abusive. So we're trying any way we can in the bill to say we are not trying to prevent meritorious lawsuits, but this is a real problem that has to do with legal shakedowns where the intent has nothing to do with compliance.
Thank you so much. I appreciate that. And I have not yet seen the balloon, so I appreciate you trying to kind of walk me through that. So thank you very much. And thank you, Madam Chair.
Thank you, Senator Gossage.
Thank you, Josh, for being here. And thank you, Madam Chair. I just have a real quick question. In reading through some of the opponent testimony, have you seen any of the opponent testimony? Are you aware that and I know they haven't spoken yet, but that they consider this too broad and have made some suggestions? Have you seen that at all? Talking about website access.
Yes, and so that is part of what the balloon is attempting to do. This isn't the end of the conversation. This is not a take it or leave it. We're doing our best to find a solution to a problem that could throw the baby out with the bathwater, so to speak, in terms of if we get this wrong. I think the metaphor in the House hearing was driving a toothpick in with a sledgehammer instead of hitting the nail on the head. And so we definitely want to bring this to an appropriate solution. We have included at the DRC's request a purpose statement to make it clear this has nothing to do with deterring meritorious lawsuits. We also are recognizing that, and to get to Senator Corson's question, not only DOJ and private lawsuits, but also there are P&A organizations, of which the DRC is one of them in Kansas, that receive federal funds in order to assist and bring these types of lawsuits. We are wanting to have a rebuttable presumption that anything that is brought by these organizations, including the DRC, would be not abusive. We want to encourage continued conversation about what compliance looks like and not be a bar to the court system for those meritorious lawsuits. So those are kind of the three prongs of enforcement under the ADA. We're trying to bring in as much of that feedback as possible, as well as limit it to just websites at this point, even though this is not limited to websites. I could talk about the gas station videos where the gas stations in Kansas were sued based on the fact that there's no closed captioning. And so ultimately, the only solution they could find was to turn off the videos. And so there's different the sky is only limited to and the range of possibilities of types of lawsuit is only limited to the creativity of the plaintiff's bar. But for now, we know that the websites, especially since there is no agreement on what accessibility looks like and compliance looks like, and the plaintiff's bar is not willing to tell us that, ultimately, we need some solution, and this starts on a limited scale.
I would agree. There definitely needs to be a solution. Thank you so much, Madam Chair.
Thank you, committee. Because it was part of testimony by Eric Stafford, We're going to pass out the balloon amendment since he did reference that, and you can take a look at the language there. And just to clarify, Mr. Nye, for those following along online, you've mentioned a couple times DRC. Could you explain what the initials stand for?
Disability Rights Center. Thank you. I was going to say, I am pinch hitting for my law partner today who's on Navy orders and playing a little bit of catch up. This is his case, but they've been working on at least a conversation. I don't think there's agreement like Eric said yet, but the reference that I indicated is on the back on subsection E, where it says if the this is the balloon part, if the litigation alleging an access violation is brought by a Kansas designated protection and advocacy agency recognized under federal law, or such a Kansas designated protection and advocacy agency recognized under federal law authorizes litigation alleging an access violation in writing, with such authorization attached to the petition in the litigation alleging an access violation, there shall be a rebuttable presumption that the litigation alleging an access violation is not abusive. So we're wanting to bring them into kind of a protective shroud to say, no, we want meritorious lawsuits, especially within the state. But this is a unfair trade practice of a whole nother category out of New York.
Thank you. Thank you for clarifying the use of an acronym in your testimony. Appreciate that. Committee, we're going to take one last question for our proponents from Senator Gossage, and then we do have to move on.
Thank you. Just a clarification, Josh. So this is on page 3 of the testimony from the opponent that we saw of a recommendation. Is this more of just a copy paste? Or has there been some changes from page 3?
I don't know the answer to that.
Okay.
You're saying as far as the purpose statement?
Yes.
I believe it's copy paste. I'll let the opponents speak to that.
Thank you. Thank you, Madam Chair.
Thank you. Committee, you do have in your documents proponent written only testimony from Kelly Vanzwall, Assistant Vice President, Government Relations with the Kansas Bankers Association. And with that, then we will invite our opponent conferee. First in person is Lane Williams, Legal Director, Disability Rights Center of Kansas, for 3 minutes of testimony. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Lane Williams. I am the legal director at the Disability Rights Organization. We are the protection and advocacy organization for people with disabilities in Kansas. Been designated that organization since 1977. It's creatures of federal law. Provide legal and advocacy services and disability rights issues, including Title III or public accommodation access violation issues. We oppose the bill that's being proposed because it's too broad. We recognize and do not condone in any manner the abusive use of access litigation out of state against Kansans trying to do what they're supposed to be doing under the ADA. But these filings are out of state litigation solely for the purpose of generating attorney fees. But this bill will target potentially all litigation on all access issues regarding public accommodations filed in state courts by allowing for a completely separate litigation challenging whether that initial litigation is abusive regardless of the merits. So you end up with two competing lawsuits, maybe not even in the same county court. We find that to be way overbroad because it has a big chilling effect upon any meritorious claim filed by a person with a disability. The bar that represents people with disabilities in Kansas on access issues is pretty small. So it's not unusual for one attorney to have brought multiple lawsuits on access issues throughout the state over the course of time. That in itself can be the trigger for a defendant in an access case of any type, not just web access out of state, to then send a demand letter off or file the litigation separately And as an attorney, I need to tell my client if I'm representing that individual in an access litigation case potentially, that is a potential detraction and could come back to require the plaintiff, regardless of the merit, to have to defend separately and incur costs and potentially attorney fees and penalties. Our position is that if you're going to craft something to address this problem, we agree it's a problem and that no small business in Kansas should have to go through this, that it should be targeted to out-of-state web access litigation cases. If there are other types of cases which the proponents can document that are being filed by out-of-state litigants using tester plaintiffs with disabilities who may be part of a paid program, we don't know that, then I think that needs to be addressed, then the legislation should address that, but not include all other access cases of any type on public accommodations filed by Kansans in Kansas courts. As the proponents have stated, we have had conversations with them about this. We're willing to continue to work. We know there's a short timeline for it, but we believe that as written, it's too broad. Thank you.
Thank you. Next, we will hear from Amy Heighton, Executive Director, Topeka Independent Living Resource Center.
Hello, this is Amy. I'm on the WebEx.
Yes, please introduce yourself and welcome to committee.
Okay, great. Thank you. Thank you, Senator Warren, and members of the Senate Judiciary for the opportunity to sort of follow along with Lane's testimony on opposing Senate Bill 258. I have written testimony that's been submitted as well, and so I don't really belabor the point sort of beyond what Lane's comments were because we agree completely. But I do think actually that as I got to thinking about the bill, that there are a couple of other points that I'd like to make with respect to how sort of overbroad, I think unintentionally, but overbroad this legislation is. And so when we're talking about the type of public access and public accommodation cases that would create this barrier for plaintiffs in Senate Bill 258, we're not really, I mean, and I appreciate, again, I stand with Lane in appreciating the issue of the out-of-state and these web cases as well. And I recognize that we are talking, in these instances about small businesses, but the way that this legislation is written, it also would include the other types of public accommodations, the Walmarts, the banks, the medical facilities. So, that title in the ADA is really very broad because it was intended to create access for people with disabilities where access was being denied. And so their ability to live and work and function in the community was compromised and was causing institutionalization. And so I do think that one of the concerns about the overbroadness of the legislation is that it isn't just the way that it's being written isn't just targeting these small businesses. It would create a doorway for larger businesses who would have no problem, hiring attorneys to file this separate case in Kansas to try to protect their business interest as well. Additionally, this bill makes no distinction between the types of accommodations that people with disabilities need in order to access public accommodations. So, obviously the thing we all think about is ramps and stairs. Now there's this issue of website access. But most of the types of ADA claims that people have with respect to these public accommodations are really just modifications to policies or procedures, not even things that cost money to those, to those businesses. A no pets policy that would allow a veteran to bring in their service dog, for example. Those are a lot of the types of cases that we see. But again, Senate Bill 258 would allow, would allow sort of a defensive position. So if somebody comes to somebody like Lane or I and is needing help with that type of an accommodation, we then, of course, would have to start with the disclaimer that Lane referenced as well. Again, we appreciate the efforts to try to sort of on a quick timeline, find a way to narrow the scope of this bill. But we do have, some pretty serious concerns about the effect it would have on people with disabilities' ability to help build a better community for all of us, to make access available to everyone. So thank you for your time. I certainly stand for questions at the opportunity.
Thank you. Appreciate that. Those following along online, the reason the camera was on the committee meeting room was with the camera was turned off for the conferee. With that, then we will open it up for committee questions for our opponent conferees. Are there any questions? Senator Wilborn.
Thank you, Madam Chair. I would more than have a question, I have a statement. I think this is a serious problem to shake down. I hope everybody can get together and get this worked out, because small business operating after coughing up $15,000 to defend a case or whatever is a huge burden on their storefront and their operations. So let's get this moving. Let's find a solution, and let's get it out of the Senate. Thank you.
Thank you. I do have one question for Mr. Williams, having now heard in committee both proponents and opponents. With the balloon amendment and the rebuttable presumption that would be had in it, if DRC is given authority to verify that cases are not abusive, would that help some of the concerns that you raised, allowing meritorious claims to proceed, and would that help?
Well, we appreciate being given the credibility to be able to make all of those judgments, but I think that would require attorneys to come to us pre-filing to say, give us your blessing on the merits of this case. And that's just not something our organization can do. As we've said before, that we are talking about that and other issues. That is a concern that came up during the conversation. It's not a foregone conclusion that we're going to say no, but we also need to talk with Amy's organization and other stakeholders in this before we can make a determination whether that is helpful. It's just the issue of us having to take a look at other people's litigation or proposed litigation is troubling. I think it's difficult for us as a small organization too.
We'll appreciate the testimony from both sides today, that it sounds like there are conversations that have been had and that are ongoing. So appreciate that.
We've had 2 meetings so far, and we recognize that something needs to be done by, I think, the 15th. And we're certainly.
I don't have the calendar in front of me, but we are on a short timeline. Yes. Yep. Other questions? Yes, Senator Gossage.
Thank you for being here. Thank you, Madam Chair. I mentioned the balloon, and the statement from the balloon appears to me to be basically a copy paste of the first recommendation from your organization. Is that correct?
I believe it's very similar. I'm not exactly sure what the change is. We had a general brief discussion about it on Friday with the proponents, but they did not specifically identify it, and I didn't go back through word by word yet. So,
thank you.
But I think the spirit of it is similar, but the purpose of it is to say that this bill is about out-of-state web access litigation. The problem with us is that the bill itself doesn't expand that. And so while the declaration of intent is a good start, it may provide guidance. The exact wording of the bill says something completely different. And I think that the courts they tend to look at the exact wording first before they go back to that.
Thank you. And thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none, then. Committee, please note that you do have opponent written only testimony from Joseph Molina, Kansas Bar Association, Barb Conant, Can Care Advocates Network, co-administrator, and Callie Denton, Kansas Trial Lawyers Association. Are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will close the hearing on Senate Bill 258. And thank you all for your attention to that matter. We will briefly open the hearing because we do have one conferee, the hearing on Senate Bill 265, which increases the criminal penalties for repeat violations of a protective order. With that, a brief from the revisor.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Very quickly, the bill is amending KSA 215924. That is our criminal code statute defining the crime of violation of a protective order. There are two changes in the bill, both to the penalties. Current law, general violation of this statute is a Class A person misdemeanor. The bill proposes that a second or subsequent violation will be a severity level 7 person felony. And then current law violation of an extended protective order, which is a special kind of order under either the Protection from Abuse Act or the Protection from Stalking Act. Those are a severity level 6 person felony. And the bill proposes to raise that on a second or subsequent conviction to a severity level 4 person felony. I don't know if you have your sentencing grids handy like Scott Schultz asked us to in your folders, but you'll see that by going to a 7 and with 1 person felony from this prior conviction already in your background, you're looking at in 7D would be your category minimally with 1 person felony. That's a range. The middle of that is 24 months, so 2 years. And then if you're looking at the other more severe penalty for the heightened level 4 from current law level 6, the level 4, again, D would be the minimum because you have a person felony in your background. That middle number is 66 months. So you're looking at 5.5 years. So just wanted to point that out to the committee. I'm happy to answer questions.
Thank you. Committee questions? Seeing none, then we will invite our proponent conferee. Due to time, we'll keep your testimony to 3 minutes, please. Thank you. Mr. Philip Journey, Judge, District Court, 18th Judicial District. Welcome to committee. Make sure your microphone is on, please.
Oh, now it's
there
on.
We go.
Okay. Well, I want to thank the committee and the chairman for letting me have a hearing on Senate Bill 265. I'm currently a district court judge, largest city in the state, second largest county. I have equivalent of about 100,000 people's divorces, paternity cases, restraining orders. What I want to urge the committee to do is I want you to go to the website and get the KBI's 2021 domestic violence report. It is telling. And just to kind of give you some highlights, about 18.5% of the 2021 homicides were domestic violence related. That was a low number. The 4 of the last 6 years were higher than 18.5%. PFAs, protection from abuse restraining orders, were at a very high number in 2021 of 8505. That was up 21% from the previous year. PFSs, protection from stalking orders, were up 18.5% from the previous year. It's quite clear that when people get these orders, they need them. I want you to understand that these statistics on how many thousands of domestic violence incidents we have, or how many thousands of arrests we have, or how many thousands of petitions we have, that each one of those numbers is a family, is someone who's been abused and children that have watched it. And what we've learned from society and science is that when they see these kinds of acts, they're basically changed for the rest of their lives. The way their brain develops from an adverse child experience changes them permanently. And they end up learning the behavior that they've witnessed and applying it in their adult lives too. It is important to understand that these restraining orders are there for a purpose, that they're intended to truncate or end the cycle of violence that comes with domestic violence. And you can see in my testimony, and I know I'm out of time, that there are several incidents that are quite horrific in both Johnson County, Sedgwick County, and all over the state. I hope the committee also considers the other 2 bills that are in this package, 266 and 267, which are yet to be set for hearing. And they essentially help try to close some of the gaps that we've got in Kansas and get us out of the 19th century and into the 21st when it comes to addressing domestic violence. Thank you.
Well, thank you, Judge. You were well under your time, sir, and wanted to recognize you as a former senator in the
Yeah, I
state.
worked in this room for several years. Maybe I'll come back. I don't know.
Well, well,
You know,
welcome back
making
today.
policy is a lot more fun than applying it to people. And you know, the food is better too.
Oh,
So,
well, committee, are there any questions for our conferee? Senator Haley.
I'll be brief. Thank you, Madam Chair. I too wanted to welcome former senator. I think you're vice chair of this committee at one point. Very active member.
I think it was claims against the state. That was the one I got to run.
Okay,
that one was so much fun.
Certainly welcome back,
Yeah.
Judge Journey, to the Senate. I'm concerned about the bed space impact. I certainly appreciate the representation that you brought, but I am concerned about the elevated bed space that we would bring. Is there some other means by which we might employ to have these very heinous repeat offenders find some other means other than clogging our cells that you might recommend?
Thank you. You know, if there's something we can do to help stop this cycle early, it will do more to save resources for the state in the long run. It's difficult to prove a negative, but there's no doubt in my mind that it is important for these children and for these families to break the cycle, to help the offender understand the ramifications of the choices they're making, and to give the information necessary to the victim so that they can get the help and find it. Because it's really tough to, you know, if you're out in Garden City, you may not know that the shelter is over in Ford County. And that's really important. That's what some of the other bills do too, is try to get that information out there so people know what kind of help's available and where to go get it.
That wasn't directly on point, but I really appreciate the stab you took at it. Thank you, Phil. Thank you, Judge Journey.
I appreciate it.
It's good to see you. Welcome back again, and thank you, Madam Chair.
Thank you, committee. The judge's testimony is on the website. We didn't have paper copies yet to distribute to committee. Are there other questions? Senator Gossage.
Thank you, Madam Chair, and thank you for being here. I have my chart out, but being a non-attorney and not as familiar, I was trying to look at the difference between a level 6 and a level 7.
Okay, the difference is basically in the disposition of the cases. So if you're a level 4, you are even if you're a criminal history score of I, you are a presumptive prison box, but the judge has the option of granting probation with a departure. 6, it's basically, you know, you look at the grid, it's the severity of the crime on the vertical axis, and it's the criminal history score on the horizontal axis. And the further they go to the left, where they get this criminal history score of A with 3 prior person felonies, the more severe the penalty is. And so the grid takes into account prior behavior. It's important to remember that if a prior conviction is used for enhancement of a severity level of the subsequent crime, it's not used again to enhance the penalty on the grid box. So, you know, there's not a double counting there. They don't get a double whammy that way.
Thank you, committee. Other questions? Seeing none, then thank you very much, Judge Journey, for your testimony today, and good to see you back. We do have proponent written only testimony from Ed Klump, Legislative Liaison, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association, as well as from Jessa Farmer, Kansas Coalition Against Sexual and Domestic Violence, and Christine Vince, private citizen. Are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will thank the judge for his testimony today and close the hearing on Senate Bill 265. Thank you, committee, for your attention today, and we've run a little bit over time. We do have committee meeting minutes that have been at your desk from February 13 through February 21 of 2023, submitted for your review and approval. Do we have a motion on those minutes? Senator Olson with the motion and Senator Gossage with the second. We will vote then. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you all, and we are adjourned.